number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Spengler, and Ms. Nelson, and the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. Before we start, let me give everyone the announcement that I have been making each day this week in case that there are people here who have not heard it yet. I want to remind everyone in the gallery that this is a public proceeding, and I want you to feel welcome and comfortable here. That is very important to me. As I have mentioned before, this is your justice system. You have every right to be here. Some of you in the courtroom are victims in this case. You have a constitutional right not only to be here, but to speak at the hearing, and you have been heard at the hearing. However, you must observe proper courtroom decorum. I am sensitive to the fact that this case may evoke powerful emotions. I fully understand that. I have not prohibited emotional reactions. To the contrary, I have recognized that most visible emotional reactions are inevitable and appropriate. What I ask is that you please follow all of the rules of the court. With one exception by someone who is not involved in this case, there have been no issues from anyone in the gallery in these proceedings. I thank you for that. I appreciate everyone's willingness to follow the court's orders. And I ask that you please continue to conduct yourselves in the same manner that you have done throughout the proceedings. Please remember that it is my duty and responsibility to defend and uphold the authority and dignity of the court. Earlier today, the prosecution filed a motion for restitution findings and order of judgment. And Ms. Stitch McGuire, it looks like you have figured out that at least as of right now, the amount that you would be seeking would be no less than $796,262 for payments made on behalf of the victims by victim compensation. Is that right?
That's correct, Your Honor.
And you're asking at this time to reserve restitution for 70 days, is that correct?
Correct, Your Honor.
So you're not asking the court to take any action at this time other than to allow you to reserve, which you're entitled to do under the statute, is that correct?
Correct, Your Honor.
All right. Any position by the defense? Mr. King?
No, Your Honor, that was exactly how I was going to ask the court to proceed as well. And
Okay.
We're in receipt. I don't know that we're going to file an objection or anything, but we'll take a look at it.
And the reason for the request to reserve is because you want to make sure that whatever amount you seek is an accurate and complete amount.
That's correct, Your Honor.
All right. That request is granted then.
Thank you, Your Honor.
Before I proceed, I need to advise the defendant. I know that yesterday, Mr. King, you said that you're not intending to appeal, but I'm going to give this advisement because I'm required to give it to your client. Mr. Holmes, I need to advise you that pursuant to Rule 32C of the Colorado Rules of Criminal Procedure, the court is required to inform you of your right to seek review of the convictions and sentences in this case and the time to file a notice of appeal. Under Rule 4B of the Colorado Appellate Rules, except as otherwise provided in Rule 4E of the same rules, the Colorado Appellate Rules, in a criminal case, the notice of appeal by a defendant must be filed in the appellate court, and an advisory copy must be served on the clerk of the trial court, that is, this court, within 49 days after the entry of the judgment or order appealed from. If a timely motion in arrest of the judgment or for a new trial on any ground other than newly discovered evidence has been made, an appeal from a judgment of conviction may be taken within 49 days after the entry of an order denying the motion. A motion for a new trial based on the ground of newly discovered evidence will similarly extend the time for appeal from a judgment of conviction if the motion is made within 14 days after the entry of the judgment. A judgment or order is entered within the meaning of this advisement when it is entered in the criminal docket. Upon a showing of excusable neglect, the appellate court may, before or at any time after the time has expired, with or without motion and notice, extend the time for filing a notice of appeal for a period not to exceed 35 days from the expiration of the time otherwise prescribed by Rule 4B. Pursuant to Rule 32C, and given your custodial status, the court determines that you're indigent, and the court therefore informs you that you have the right to the assistance of court-appointed counsel for the purpose of seeking review of your convictions and sentences. Further, the court informs you that you have the right to obtain a record on appeal without payment of costs. The court advised you earlier of your right to seek review of your convictions and sentences. The court must also advise you of the right to seek a post-conviction reduction of your sentences in the trial court, that is in this court, under the provisions of Rule 35B of the Colorado Rules of Criminal Procedure. That rule provides that the court may reduce the sentence imposed on a defendant, provided that the defendant files a motion for reduction of sentence within 126 days or 18 weeks after the sentence is imposed, or within 126 days or 18 weeks after receipt by the trial court of a remittitor issued by the appellate court upon affirmance of the judgment or sentence or dismissal of your appeal, or number 3, within 126 days or 18 weeks after entry of any order or judgment of the appellate court denying review or having the effect of upholding a judgment of conviction or sentence. In this case, you're looking at multiple life sentences without the possibility of parole. So I don't want anybody to be confused by the advisement in terms of the court being able to reduce those sentences. The court does not have the discretion to do that. The court will not reduce life imprisonment sentences, but it's an advisement that I'm required to give. There is also an advisement that's required under Colorado Revised Statute, Section 18-1.3-404, which states as follows. It requires me to tell the defendant the following, that he may spend less time incarcerated than the term announced here today. The actual time served will be influenced by a number of factors, including but not limited to previous criminal activities, eligibility for earned time for good behavior, correctional education program earned time, credit for time served, or community corrections eligibility. Again, I don't want anybody to be confused. This is an advisement that I have to give. In this case, the defendant is looking at multiple life sentences without the possibility of parole. So this advisement really doesn't apply to him, but the law requires me to give it in every case, and so I have given it. Any other advisement that either side wishes to request at this time from the people?
No, Your Honor, thank you.
From the defense?
No, sir.
Is there anything else before I proceed from the people? Mr. Brockler?
No, Your Honor, thank you.
From you, Mr. King?
No, Your Honor.
All right. Probably what we will do is I will make some comments, and then I think what I am inclined to do is take a short break and then proceed after that with my sentence, okay? So for purposes of my comments, it's okay if the defendant stands seated, and then once I'm ready to sentence him, I will ask him to go to the podium, and Mr. King, you can accompany him at the podium, and then we'll proceed in that fashion. I have talked about the justice system a couple of times during the last couple of days, and I hope that nobody has been offended by my comments. I stand by my comments. It's not that I'm insensitive to the pain and the suffering that the victims have gone through, and I understand why in that situation it is difficult to be objective, but I believe in this system. I said that yesterday, and I'll say it again. I believe in this system. This is as good a justice system as there is in the world. And even though you may disagree with some of our laws, or you may disagree with the outcome of the case, in the end, the system works. and it worked in this case. And that doesn't mean that it's a system that it's infallible. It is not a perfect system. You're never going to have a perfect system because we're all human beings. And we're all fallible. We all make mistakes. And this is a system that is operated just like any other system by human beings. And so you're never going to have a perfect system. But our system is based on having a jury, members from the community, come in here, give us their time, and do their best to be fair and to be impartial and to apply the law that the court gives them. And it is based on the judge presiding over the case doing his utmost to be fair, to be impartial, and to apply the law to the best of his ability. And it involves lawyers who have a job to do. The prosecution has a job to do, to zealously represent the people of the state of Colorado. And the defense has a job to do, to zealously represent the defendant. And it's an adversarial system. And so because of that, it's not unusual that at the end of the trial, you're going to have some people who are not going to be necessarily satisfied with the outcome, or perhaps may not get the outcome that they desired. But that doesn't mean that the system is broken, and that doesn't mean that justice was not done. It's the process that you have to look at. I think I asked a question a couple of days ago. If I had asked you folks the day before the final sentencing verdicts whether you felt that the trial had been fair and had been impartial, whether you felt that both sides had received a fair trial, how many would have said, oh, there's no justice, or this justice system doesn't work? Now, I don't know the answer to that, but I would venture to guess that if you were honest about that you would say that most of you would have felt that the process had been fair and impartial. At least that's my hope. Now, having said all that, I got the sense from listening to some of the victims during the last couple of days, either because they expressly said so or because they implied it, that they felt like the defendant prevailed in this case. So let me address that, because really it depends on your perspective. Perspective is defined by Merriam-Webster's online dictionary as the capacity to view things in their true relations or relative importance. Another dictionary defines perspective as a way of regarding situations and facts and judging their relative importance. So, when it comes to the outcome of the case, is the glass half full or is it half empty? That's a philosophical question that I'm sure most of you are familiar with, and that is commonly asked or used to demonstrate that a situation may be seen in different ways depending on your point of view. One person may view a situation as positive, while a different person may view the same situation as negative. It is the same situation. The only difference is the perspective of the viewer. Perspective is, of course, unique to each individual. And perspective is the individual's interpretation of reality. And the great news is that we have complete control over it. Nobody can tell you what your perspective should be. That's up to you. It's up to each and every one of you. Each of us has the power, if we wish to use it, to determine what perspective we will have about a situation, how we will view a particular set of facts or a particular situation. Will we view it, will we choose to view it as a glass half full, or will we look at the glass and say it's half empty? I know it seems like a long time ago, but it was actually only last month, on July 16, a jury of the defendant's peers, 12 members from the community, who had given us their time their effort, their best in a very difficult case, under very difficult circumstances, walked into this courtroom and they informed us that they had found the defendant guilty of all 164 substantive counts in this case. Guilty on all 164 charges. I think it took me an hour to read all those verdict forms. The jury held the defendant accountable for his actions in this case. And it was hard to avoid the news after the fact. And I heard some victims say after those guilty verdicts that they were satisfied, very satisfied with the verdicts, and that they would accept either sentence, that the outcome of the sentencing hearing really didn't matter at that point. They were just relieved to get guilty verdicts. And then I have heard some of those same folks say later, after the sentencing verdicts, that they're disappointed in the outcome. And you know what? That is completely understandable. This doesn't mean that there is something wrong with you. There's not anything wrong with you. It is completely understandable. And I think it's a psychological phenomenon. You feel disappointed because you went through the sentencing hearing in front of the jury, and the jury was not able to return the sentencing verdict that you were hoping for, or the sentencing verdicts that you were hoping for. The jury was not able to reach a unanimous decision on sentencing. So it feels like rejection. It feels like you asked someone for something and that someone said no. It feels like defeat. But the truth is that nothing in the sentencing verdicts, nothing changes the guilty verdicts. Those guilty verdicts that were returned on July 16 are still standing. They have the same effect and significance today that they did on July 16. So if on July 16 you felt satisfied with the outcome, then think back to July 16 and think back to the perspective that you had that particular day after the guilty verdicts were read. If, as is the situation in 99.9% of first-degree murder cases, the prosecution had been seeking a life sentence without the possibility of parole in this case, you wouldn't be feeling like a life sentence means that the defendant prevailed. You would be very satisfied with that sentence. Again, it's a psychological phenomenon. Because you were seeking something else, then it feels like rejection. And again, it is completely understandable. Now, I get that those victims who wanted a death sentence are disappointed in the final sentencing verdicts. I understand that. But does that mean that the defendant prevailed? I suppose it depends on your perspective. Is the glass half full or is the glass half empty? Well, let's talk about it. First, let's be clear about something, because I heard some victims say the last couple of days that the defendant essentially got what he wanted. And you know, I don't remember the defendant or any of his lawyers ever saying in this courtroom to me that the defendant wanted a life sentence without the possibility of parole. Those words were never uttered throughout these proceedings. In all my years as a litigator and on the bench, I have never, ever heard anyone say that he or she would like a life sentence without the possibility of parole. And that's been no different in this case. What the defendant has requested since June 4 of 2013, more than 2 years ago, when he pled not guilty by reason of insanity, is to be excused for his conduct, to avoid being held responsible for his conduct, and to be sent to a hospital. Certainly that's what he sought throughout the trial. That's what he asked the jury to do, beginning in January all the way through July. Was that the outcome? No. Now, I understand that in a pleading filed back in March of 2013, there was an indication that the defense had informed the DA that the defendant was willing to accept a life sentence in exchange for an agreement by the prosecution not to seek the death penalty. I'm not privy to the plea negotiations that may have taken place, so I don't know what negotiations took place or what was said by whom during any negotiations that may have taken place. But even if that's what happened, even if negotiations took place and the defense said that to the prosecution, being willing to accept a life sentence is not the equivalent of wanting a life sentence. Defendants in criminal cases frequently are willing to accept or to tolerate a prison sentence of some type, not because they want to go to prison, not because they like prison or because they want a prison sentence, but because they want to avoid the risk of proceeding to trial and ending up with a harsher sentence as a strategy, because it's the best option available. And if a plea bargain is reached in a criminal case, it doesn't mean that the defendant gets what he wanted. He gets what he's willing to tolerate or accept, as hard as that pill may be to swallow, in order to avoid the risk of receiving harsher punishment at trial. I heard in some of the comments people imply that then we would have been better off just with a plea bargain and that the trial was a waste of time and money. And I have to tell you, the court had no involvement whatsoever in the decisions that were made that led to this case proceeding to trial. And the court cannot comment on those decisions. Nobody has challenged any of those decisions in a formal court proceeding. Nobody has argued that there was anything improper about those decisions. And I don't have any knowledge of it. I don't make those decisions, and I don't get to be involved in those decisions. Once those decisions are made, I respect them, unless there's a reason not to. And in this case, nobody presented me with a reason not to. Nobody argued that there was a reason not to respect those decisions, and the court respected those decisions. But now that the trial is over and you know the outcome, people have a choice, and that includes all the victims. Do you second guess those decisions and focus on regretting those decisions? Or do you look at what came out of the trial? Well, is the glass half full or is it half empty for you? So I thought about this some and thought about the sentencing hearing. And so I'm going to ask some rhetorical questions, because I asked these questions as I heard some of those comments in my own mind. I wonder what people's reaction would be. Was it a waste of time when Chantel Blanc, Jonathan Blanc's wife, told the jury about how Mr. Blanc was a strong person who was able to overcome many obstacles early on in his life, and that the challenges in his past helped shape the man that he became? And was it a waste of time when she informed the jury that Mr. Blanc was working to re-enlist in the military and that they had 2 young children together? Mary Teresa Hoover, A.J. Boyd's mother, told the jury about Mr. Boyd's bright personality, including his great sense of humor, as well as his many interests and talents, and that he was planning to attend art school. She also testified about his love for his fiancée, La Samoa Cross. Was all of that a waste of time? Was it a waste of time for Lisa Childress, Jesse Childress's mother, to inform the jury that her son had a great sense of adventure, that he was involved in a lot of sports activities, that he traveled, that he was in the U.S. Air Force, and that the last time the family was together was in Manitou Springs? Sierra Cowden, Gordon Cowden's daughter, still a teenager, had the courage to do something that many adults would not have been able to do. She took the witness stand to tell the jury about her dad. She cried multiple times as she testified, but she at no point asked to stop. She did not quit. Despite the tears and the emotion, she hung in there, and she managed to stay composed so that she could tell the jury about Gordon Cotton's qualities as a father of 4 children and about how much she misses waking up to her father singing in the mornings. The Sierra Cotton wastes her time, the jury's time, and our time coming in here and fighting through tears to introduce her dad to the jury. Sandy Phillips, Jessica Gowie's mother, told the jury about Miss Gowie's great enthusiasm for life and about the close relationship that she had with her daughter. She informed the jury that Miss Gowie moved to Colorado to pursue her career as a sportscaster, specifically in hockey. And we were shown a funny video of her pursuing that dream. Was all of that a waste of time? Kathleen Larimer, John Larimer's mother, told the jury about her large family, her son's upstanding character from a young age, his enlistment in the Navy as a 4th-generation veteran, his great work as a young cryptologic technician, and his great talent at trivia games. Did Miss Larimer waste everyone's time as she introduced her son to the jury and told the jury about how wonderful her son was? Matthew McQuinn had Jerry Jackson, his mother, come in here and testify about how important he was to his family. Mrs. Jackson told the jury that when she went to the coroner to identify her son's body, she told him that she loved him and that she was proud of him because he saved his girlfriend's life in the theater. Was it a waste of time for Miss Jackson to tell the jury about her son? Amanda Medic, Michaela Medic's sister, told the jury about Michaela and what a soft-hearted person she was, and about how she was always calm, and about how she recently began living on her own as a new college student. She testified that Ms. Medic was her grounding force and that it's been difficult adjusting to life without her sister, to life as an only child. Did Amanda Medic waste her time? Robert Sullivan, Veronica Mosher Sullivan's grandfather, testified about her angelic personality and his joy in attending her continuation ceremony. And I think we all remember Ashley Mosher's testimony and how she told the jury about the fact that being Veronica's mother defined her, that she misses her little silly Billy, and that she doesn't know who she is anymore without her daughter. Did Robert Sullivan waste his time? Tom Sullivan, Alex Sullivan's father, a man with a larger-than-life personality, got choked up more than once on the witness stand as he told the jury about his son's outgoing personality and passion for superheroes, about the close friendship that he and his son had, about how his life has not been the same since his son's death, and about how much he misses his son. He also told the jury that during annual trips to Las Vegas for the Super Bowl, he continues to honor his son's memory by leaving an empty chair and a shot of Jameson on the table. Did Tom Sullivan waste his time and our time and the jury's time? Karen Teeves, Alex Teeves' mother, fought back tears as she courageously told the jury about how generous and good her son was, and about how her son enjoyed working with children and helping others. She testified that she and her husband had planned to retire in Hawaii, but she can no longer be in Hawaii because that's where she was when she got the phone call about her son being in the theater during the shooting. She also informed the jury about how after the shooting, Alex's girlfriend formally changed her last name to Teeves. Was all of that a waste of time? Robert Wingo, Rebecca Wingo's ex-husband, told the jury about Miss Wingo's infectious spirit and that she was fearless and wild, yet cultured and intelligent. He testified about Miss Wingo's relationship with her 2 beautiful daughters and how their daughters no longer have their mom and no longer have a strong female role model. Was that a waste of time? Now, I understand that victims had an opportunity to come in here the last couple of days after the trial was over, and that all these folks could have said those same things here. But you know, one of you pointed out, aptly so, I think it was yesterday, that it's not the same. She said, Judge, I appreciate the opportunity to come here before you and make a statement, but it doesn't feel the same. I wanted to tell this story to the jury, and I think that would have made a difference. And you know what? I think she has a point. And so, while it is true that you would have had an opportunity to make all these statements, I don't know that it would have been the same thing. So when you think about the trial and you're trying to figure out how you want to choose to view it, what perception or what perspective you want to have, you want to choose to have, think about these rhetorical questions and answer them for yourself. There were other things that came out as a result of the trial. The trial allowed all the victims to find out all the facts. And a couple of you mentioned that the last 2 days. One of the victims said that she was in the dark before the trial and that the trial answered a lot of questions. Now, we may not have the answer to all the questions. We never get all the answers to all the questions. That's not how life works. But all the facts were revealed and many questions were answered. So another rhetorical question. Was that important to the victims? Was that important to the community? Was it important to the state of Colorado? Was it important to the rest of the country? Was it important to the world? And let's face it, this case was getting attention not only from the community in Aurora, not only from Colorado, but beyond that, from other places in the country and other places in the world. And was it generally useful for everyone to learn all those facts? Did we learn some things from the evidence presented in the trial? Are there lessons that we, all of us, can take from the evidence that was presented during the trial? Mr. King said yesterday that the defendant will not appeal, and I understand that decision and why that decision was made. That means that this case will have been completed in 3 years, just a little over 3 years. And when I say completed, it sounds like, based on that representation by Mr. King, truly completed. That's record time, folks. That's unheard of time for a death penalty case, especially one of this magnitude. Had a death sentence been imposed, I promise you, this case would have been pending in this court and in the appellate courts for years, if not decades. Does that make a difference to you? And does that alter how you view things, what perspective you have? By having the case completed with no appeals, it means that the victims don't have to be continuously worrying about whether the conviction or the death sentence will be overturned at some point in the future. Again, does that make a difference? By having the case completed with no appeals, it means that the victims don't have to be continuously hearing about the case and the proceedings for the next decade or decades to come. Does that make a difference? Now, it is true, if the defendant had pled guilty back in March of 2013 with an agreement to a life sentence, it is possible that there would have been, that the case would have been completed. But it is also possible that there would have been appeals and other post-conviction proceedings, including ineffective assistance of counsel claims. And then, of course, if that had happened, then we never would have heard from all the people who testified at the sentencing hearing. which I have mentioned a moment ago, and we never would have gotten to hear and learn about all the facts, as I mentioned a moment ago. So, again, does that make a difference? It may for some of you, it may not for others of you. As far as money goes, I don't get to decide how much money is invested in these cases or how much money is spent or how much cases cost. But what I can tell you is that without any appeals, this case will be less expensive than if there had been a death sentence. Now, it likely would have been cheaper if there had been a plea bargain, but again, we don't know exactly how much cheaper or if cheaper at all because we don't know if there would have been any appeals or post-conviction proceedings following a plea agreement. And we don't know if, as a result of those types of appeals or proceedings, that plea would have stood and we would have found ourselves in a trial anyway. Again, there is uncertainty no matter how you look at this. And speaking of money, again, it was not the court's decision and the court is not involved in any of that. But since when do we as a nation, as a community, put money ahead of everything else? When did that happen? So, let's talk about the end result. Is prison really a much less severe sentence than death? I bring that up because some of the comments during the last couple of days made it seem like death is a severe sentence, but life imprisonment is not. And the truth is that either way you look at it, the defendant is going to die in the custody of a Department of Corrections. It may not be in Colorado. I suspect that he may serve his sentence in another state. But it will be in some Department of Corrections. So the place of death, generally speaking, has been determined. And the only question that remains unanswered is the time of death. But you know what? There is no certainty again under either sentence. If it had been a death sentence, you don't know whether the death sentence would have stood after all the legal challenges. And if he had withstood all legal challenges, there's no way to tell when it would have been carried out. And with a life sentence, we don't know how long the defendant will survive. We don't know how long he's going to live in prison, how long he will survive in prison. Either way, there's no certainty. Now, I've heard some descriptions about prison during the last couple of days that, frankly, I think would make people want to sign up for it. At times, I didn't know if people were describing prison or a 4-star hotel. I mean, people were talking about free food, free medical services, free medication, cable TV, comfortable beds. And I'm sitting here thinking, wow, that sounds like a luxurious hotel. In all the time that I've been doing criminal law, it's the first time I've ever heard prison described in such manner. I think one of you put it best when you said, and one of the victims it was who said, prison is no picnic. And this is life imprisonment without the possibility of parole. So to the extent that prison is no picnic, it's even more severe because this is life for life without ever having the possibility of parole. So again, I go back to what is your perspective? What is your perspective? How do you wish to view things? You can focus on things such as visitation rights, having free food, having medical care when needed. And frankly, there's nothing I can do about any of those things, and there's nothing the parties can do about that, and Mr. Brockler made that clear yesterday. And I don't know what types of visitation rights there are going to be because that's up to the Department of Corrections. And I don't know what state the defendant will be serving his sentence in, but, you know, his parents, his family lives in California. And the chances of him serving a sentence in California, I suppose, is 1 out of 50 because there are 50 states. So I don't know where he's going to serve his sentence, but and I don't know whether he will have visitation rights, and if so, what visitation rights, and if he has visitation rights, whether it will be convenient for his family or for other people to do that. So you can focus, if you want, on those things such as free food and free medical care when needed. Or you can view the glass half full, if you wish, and focus on things such as the fact that the defendant will never be a free man again, ever. The fact that the defendant will never be able to decide what clothes to wear again. The fact that the defendant will never again be able to cook a meal or to prepare a meal or to decide when to shower, when to eat, when to sleep, or when to play. Or the fact that he will be behind bars in a locked facility for every day of the rest of his life. And that he's going to be told what to do and what not to do each and every day for the rest of his life. And that he will be in there with serious, dangerous criminals. That doesn't sound like a 4-star hotel to me. Having said all that, I think that the reason some victims have a difficult time with the punishment in a case like this one is twofold. Number one, I think it's based on what they have gone through. And number two, it's based on the nature of the crimes. And so let me take each one of those separately. First, with respect to what the victims have gone through, we don't have words in our vocabulary to adequately describe what they've gone through. There are no words to adequately describe the pain, the suffering, the loss, the sadness, the helplessness, the grief, the confusion, the anxiety, the anger, the bitterness, the unjustified but very real suffocating guilt, the resentment, and the overall anguish that the victims and their families and friends have had to endure. And part of that has to do with the way these deaths and injuries were inflicted. Many of the victims who came in here the last couple of days spoke about the horror and the terror to which the defendant subjected those in the theater and in the apartment building. I have been doing criminal law cases for the better part of 2 decades. And before this trial, I had never seen a police officer or a first responder break down on the witness stand. And in this case, we had officers and first responders who not simply got choked up, but actually cried on the stand. And that's a reflection of what they saw, of what they heard, of what they smelled, and of what they felt in that crime scene. These are folks who are used to seeing blood and are used to seeing crime scenes and are used to seeing suffering. And yet, years later, when they came in here and took the stand, they broke down and they cried. It is gut-wrenching and heartbreaking to read the victim impact statements. And I read them. They were submitted, and I read them. It is gut-wrenching and heartbreaking to hear about the victim statements that were made here in court. And as I read the statements and as I listened to the victims, the pain was palpable. I didn't need to have the victims tell me that they were in pain or that they were suffering. I knew that from reading their statements, from listening to their comments, and from watching them here in court. I cannot imagine having to experience what the victims have experienced and continue to experience. And they did not deserve any of it. Nobody should ever have to go through what so many victims and their relatives and friends have had to go through and continue to go through. On top of that is the nature of the crimes. That's the second part. The anguish experienced by the victims was caused by some of the most horrific, unthinkable, unspeakable, senseless, heinous, shocking, cowardly acts. That anguish was caused by someone who set out to accomplish mass devastation, who after deliberating about it and thinking about it, intended to kill as many innocent people as he possibly could. When you have those types of circumstances present, the understandable response from the victims is to attempt to find a punishment that is commensurate with the heinous nature of the crimes and harm caused by the crimes. And the truth is, it doesn't exist. One of you eloquently put it as follows: there is no punishment in this world that could equal even a fraction of the suffering the victims have experienced and witnessed as a result of the defendant's horrific crimes. Now, one of you mentioned, I think it was the day before yesterday, that, and when I say one of you, I'm talking to one of the victims, that she felt like the defendant should have to go through exactly what she went through. And since she was a quadriplegic, that's what the appropriate punishment should be. And you know what? I completely understand why she feels that way. But we can't do that. Why? We're a civilized society. If we subscribe to the eye for an eye and tooth for a tooth philosophy, we would be no different than the criminal who is on trial. And the truth is that we would not feel good about ourselves after the fact. We may think that way because we're suffering and we're in pain, but we would not feel good about it after the fact. We're different from the criminal who is on trial. Very different. So we do our best, the best we can within our system of justice. That's why we went to trial in this case, and that's why we had a capital sentencing hearing in this case. Because the jury could not agree on the appropriate sentence on the sentences on the counts of first-degree murder, the law requires me to impose a sentence of life imprisonment without the possibility of parole with respect to each deceased victim. I don't have a choice in the matter. That's mandatory. That's required. On the other counts, I have to decide what sentences are appropriate. And so how do I go about doing that? Well, as an initial matter, I have to give effect to the jury's guilty verdicts. As I mentioned, the defendant pled not guilty by reason of insanity and argued that he was not responsible for his actions because he was insane at the time. And there was evidence that the defendant suffered from a severe mental illness. But the jury rejected the defense of insanity. Not only did the jury reject the defense of insanity, it did so 164 times because it found him guilty on all 164 substantive charges. On each count, the jury found the defendant guilty. That includes 6 counts in which the jury found the defendant guilty of the lesser included offense of attempted second-degree murder. There was overwhelming evidence in this case to support that verdict or those verdicts, because there was overwhelming evidence that whatever mental illness the defendant may have had, a significant component of his conduct was unrelated to mental illness and was related to moral obliquity, mental depravity, or passion growing out of anger, hatred, revenge, or similar evil conditions. I agree with what Mr. Brockler said yesterday. Mental illness and evil are not mutually exclusive. And the law in Colorado recognizes that. The applicable test for insanity in Colorado states that care should be taken not to confuse a mental disease or defect that can excuse or justify a person's criminal conduct with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil spirits. Obliquity, as in moral obliquity, is defined by Merriam-Webster's online dictionary as deviation from moral rectitude or sound thinking. Depravity, as in mental depravity, is defined by the same dictionary as a very evil quality or way of behaving, an evil or immoral act. And what is the reason that the legislature cautions us to be careful not to confuse a mental disease or defect that can excuse or justify a person's crime with causes like moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other similar evil conditions? The reason is that when the act is induced by any of these causes, the person must be accountable to the law. When the jury found the defendant guilty of all the substantive counts in this case, it concluded that whatever mental illness he may have suffered from did not prevent him from distinguishing right from wrong, and did not prevent him from murdering after deliberation and with intent. The jury found that there was no mental disease or defect that was so severe as to excuse or justify the defendant's conduct. The jury found that the defendant should be held accountable to the law for his acts. So, the question that may still linger is, did the defendant suffer from a mental condition, from a mental disease or defect? And if so, how severe or serious was it? Well, that's the $64 million question, isn't it? And we tend to like simple answers. But maybe it's not so simple. Maybe it's more complicated than we would like it to be. And maybe that's because we're not where we need to be in the fields of psychiatry and psychology. I'm not throwing those fields under the bus, but I think even the experts who testified in this case would admit that we have a long way to go. Regardless of how you answer that question, what the jury's guilty verdicts reflect with record support is that contrary to what the defendant claimed during the trial, this was not all about mental illness. And there was evidence that showed that he was angry, bitter, disappointed because of the breakup with his girlfriend and his struggles in school. He felt betrayed by the universe or nature because of the many flaws that he perceived he had. He had never experienced as much adversity as he did in early 2012. Life knocked him down, as life does to all of us. Life knocked him down for the first time, and the defendant quit. He quit trying at school. Even when the school told him they would give him a second chance, he still chose to quit. His girlfriend, Miss Data, broke up with him, but she offered him her friendship, and he accepted it at first, but then he quit her friendship too. The defendant then quit all his other friends. Around the same time, he quit on the therapy that he was getting from Dr. Fenton. When Dr. Fenton urged him to remain in therapy and told him it didn't matter that he had dropped out of school, and it didn't matter that he had no insurance or money to pay for it, she would make it work, he still chose to quit. Dr. Feinstein offered to help, but the defendant quit. And at that time, the defendant really did not have a relationship with his sister and was not close to his parents. He had no other friends, and he belonged to no group that could provide support, whether religious, spiritual, athletic, scientific, or of any other nature. Eventually, the defendant quit on life. But had he just quit on life, it would have affected him and him alone. perhaps his parents, perhaps his family, perhaps those closest to him. And that would have been the end of it. But he didn't just quit. He decided that since he was quitting, he was going to take people with him. And so when you consider the fact that he quit every aspect of your life, and you add to that his long-standing hatred of mankind, his adverse feelings toward people, his desire to be remembered, and whatever mental instability he may have been experiencing, you put all that together, and it led to the unthinkable crimes that he committed in this case. On March 25, 2012, the defendant told his girlfriend, Miss Data, that he could not do what he wanted to do. When she asked him what it is that he wanted to do and couldn't do, he said, kill people. So he told her, because he couldn't do that, he was playing video games as an escape tool. Well, less than 2 months later, the defendant decided to do what he said he couldn't do in March. And rather than continue to use the video games as an escape tool, he actually killed a bunch of people and would have killed more if he had had his way. Video games were apparently no longer enough, and as one victim put it, he viewed the people in the theater as characters in his video games. In the end, what the defendant did is unacceptable. And the community, through the jury, has determined that he must be held fully accountable to the law. Our community, through the jury, sent a message loud and clear. These types of heinous, horrific acts will not be tolerated, and the defendant will be punished and must be punished severely for them. The defendant's senseless, horrific, heinous acts have needlessly impacted thousands of people. Thousands of people. He robbed 12 people of their lives, and as one of the victims put it, he took life from hundreds or thousands who are still breathing. It is almost impossible to comprehend how a human being is capable of such acts. It is almost impossible to accept that a human being can be filled with such intense anger and hatred and revenge that he is driven to commit these unspeakable acts. Especially considering that the defendant was someone who had never violated the law before, with the exception of minor traffic offenses. It is almost impossible to believe that a human being like that, who had never committed a crime, could have such anger and hatred and revenge in his heart that it drove him to kill and hurt so many innocent people. Think about that. Think about the type of intense hatred, anger, revenge, and other evil conditions drives a person who has never committed a crime to do something like this. By all accounts, many of these young victims who were in the theater were destined for greatness. And those who were a little older were already making this world a better place, a much better place. John Larimer, Alexander Teves, Jessica Gowie, Alex Sullivan, Sully, A.J. Boyk, Jonathan Blanc, Rebecca Wingo, Jesse Childress, Gordon Cowden, Matthew McQuinn, Michaela Medic, and Veronica Mosher Sullivan. We will never know what they would have accomplished. We will never know what impact they would have made in the world. The defendant robbed not only the family members and friends of these victims, but he robbed the world of all the good that these people could have accomplished, all the good that these deceased victims would have accomplished. Some of you made some requests during the last couple of days about things that the victims want the court to order. And Mr. Brockler mentioned this, but I'll mention it again. I cannot order any of those things. I don't have the authority to order the defendant to be placed in a particular facility. I don't have the authority to order the defendant to take medication. I don't have the authority to order no visitations. And I can't remember now what other requests were made. I don't have the authority to do that. We're going to take a break here in a little bit, but before we do, I want to mention that I understand that some of the victims are disappointed in the outcome, and some of the victims wanted a death sentence. But you know, your healing is not tied to the defendant's fate, and you've shown that. So many of you came in here the last couple of days and showed how courageous and strong and tough and how much grit you have. That even despite all the pain and suffering you've gone through, you're not quitting and you're hanging in there. And you're hanging in there and you keep hanging in there and you keep fighting. And you have my admiration. You have my admiration. Because I can't even fathom what you have experienced and what you continue to experience. And yet, you folks are persevering. Let me read a couple of quotes that I took down from some of the victims who were here the last couple of days, because they said it better than I could. The first one reads as follows. My final statement is this, Your Honor. Despite what some self-absorbed, inconsiderate, loveless, heartless killer tried to do, we won. All of the survivors and the victims' families, we are the ones who succeeded. We have all gone through the most difficult, heartbreaking, painful experience we could ever go through. But we are still standing. We did not fall. We came together and became something stronger than anything the defendant could ever imagine. So in the end, we won. Our lives are even more meaningful now after what he has done, because we will live to the fullest extent of life after having survived this horrible experience. And we will live for those that we lost, so that they will continue to live through us. I find that perspective admirable. Here's another quote I took down. Your Honor, we cannot help but believe that his selfish act of killing innocent people in cold blood will bring out the best in mankind. I submit it has. The letter then, the same statement goes on to say the following. There was at least one person on the jury that could not morally take his life, no matter that he has no soul, and we respect that. The outpouring of love, compassion, and support we have felt is proof enough for us that the mankind he hated and wanted to destroy has more good than evil. You know, on July 19, 2012, late in the evening, perhaps early hours of July 20, 2012, the defendant, at one point, before he went into the theater and killed and injured so many innocent people, made a phone call. And the evidence showed that he knew at that moment the difference between right and wrong. He was at a fork in the road, if you will. And he could have gone taken either one of those two roads. Had he taken one road, all of those people in that theater would have enjoyed that movie, would have come out of that movie healthy, happy, and would have gone on with their lives. And perhaps the defendant the next day would have called Dr. Fenton and gotten help. Or perhaps he would have called his parents or his friends. Or perhaps he would have been able to somehow start his life or re-register in school and get back in school, get back in the program where he was as a neuroscience graduate student. But he decided instead to take the other road. He chose to take the road that led him into that theater and killed and injured so many innocent people, and in the process caused so much pain and suffering to hundreds of people, if not thousands of people. And, you know, at least one juror showed the defendant the mercy that he refused the victims that day when he went into that theater. And really, that's not the only contrast in this case. Really, this case is a display in contrast. Whereas the defendant was not willing to be merciful and compassionate to the innocent victims in that theater on July 20, at least one juror gave her mercy and compassion. Whereas the defendant quit on life, the victims in this case to a person have shown the courage and intestinal fortitude to fight and to live while facing much larger problems than the ones he ever faced. Whereas the defendant had a long-lasting hatred of mankind and an adversity to people, the victims who have come in here and addressed the court have shown all that is good about humanity, with some of them even going as far as saying, we forgive the defendant for the horrific crimes he perpetrated against us. All right, I'm going to stop there and take a break because we've been at this for a while. When I come back, I will issue my sentences. The court will be in recess. Thank you.
Please rise.